Hi, I'm Kevin Borland, and for my Vermont Law School Environmental Law LLM mini-thesis, I chose as my topic Standing for the Citizens of Kiribati. Kiribati is a small island nation in the Pacific Ocean south of Hawaii, having nearly 107,000 resident citizens. This map, retrieved from Google, depicts Christmas Island, which comprises 70% of the land area of Kiribati. Christmas Island is famous for having been the site of British nuclear weapons tests in the late 1950s. Kiribati people are Micronesian. They speak a language called Gilbertese. They have a rich culture of which dance is a significant component. These children in traditional dress are preparing for a ritual dance performance. Global climate change brought about by carbon emissions from industrialized nations has caused a rise in sea level, which within the next 30 to 50 years will render the entire nation of Kiribati uninhabitable. This is not hypothetical. Already, Kiribati villages suffer from massive flooding from both rise in sea level and from a trend of increased storm intensity traceable to anthropogenic climate change. One of the primary sources of the carbon emissions driving global climate change is the utility industry in the United States. American power plants burn fossil fuels to create electric power, releasing massive amounts of carbon dioxide, a greenhouse gas, into the atmosphere. My thesis discusses whether the citizens of Kiribati may have standing to sue the American power companies in federal court in the United States, seeking compensation for damage to their property and funding to relocate and preserve their culture. The citizens of Kiribati will not be able to afford relocation on their own, as the per capita GDP in their country is about $1,800 annually. To establish standing to sue in the United States federal court system, a plaintiff must prove 1. That he has suffered an injury in fact, 2. That a causal connection exists between the injury and the conduct complained of, and 3. That it is likely that the injury will be redressed by a favorable decision in the court. As the second and third elements are easier to establish, I'm going to focus on the first element requiring an injury in fact. An injury in fact is an actual or imminent invasion of a legally protected interest, which is concrete and particularized. The primary obstacle for citizens of Kiribati would be proving that they have a legally protected interest. That is, an interest protected under American law. The reason for this is that they are non-resident aliens who are being harmed outside of the jurisdiction of the United States. In American law, legally protected interests can be derived from a variety of sources, most notably common tort law, statutory provisions and the administrative regulations authorized by statutes, civil rights guaranteed by the Constitution, and international law to some extent. For the citizens of Kiribati, pursuing an ordinary tort claim in the United States federal courts would be futile as a result of the holding in the case styled Berlin Democratic Club versus Rumsfeld. In this case, citizens of West Germany attempted to sue in the United States federal court system, alleging grievances related to the policies of then-President Nixon. In this landmark case, the Federal District Court for the District of Columbia held that the non-resident aliens could not establish standing to recover for injuries suffered abroad, except where a specific statutory scheme permits suits by non-resident aliens for injuries suffered under the statute. 34 years later, in the case of Brady versus Sea Services, LLC, it was brought before the Federal District Court in the Eastern District of North Carolina. Brady was a lawsuit seeking compensation for the wrongful deaths of 9 Iraqi citizens killed in Iraq due to the operations of Blackwater, a United States governmental security contractor. They alleged that the Federal Tort Claims Act might fit within the narrow exception of the Berlin Democratic Club case. The case was unsuccessful because the FTCA does not specifically confer rights upon non-resident aliens overseas. Such an interpretation would also require the United States federal courts to apply the Iraqi tort law. As Iraq was the situs of the tort, as a practical matter, it would have been unclear as to what tort law to even apply, if any, in a nation undergoing a civil war. Fortunately for the families of those injured, the case was not dismissed but remanded to state court, after which an amicable settlement was agreed upon. So what about a legally protected interest in constitutional law? For example, maybe the citizens of Kiribati can make a claim under the Takings Clause. Does the United States Constitution confer rights to non-resident aliens injured abroad by American citizens? First, it would have to be established that the utility companies are state actors, perhaps as a result of federal subsidies accepted. The controlling case regarding this legal theory is Giffrey versus the FAA, the Federal Aviation Administration, decided 2004 by the Third Circuit Court of Appeals. Jeffrey was a widely publicized case where Saudi Arabian nationals were denied American pilot licenses by the FAA in the wake of September 11th attacks in New York, Washington, D.C., and Pennsylvania. The theory of the case was that the United States violated the due process rights of the pilots and arbitrarily denying them licenses based on their country of origin. The court denied their claims, leaving little room for exception, stating, "Non-resident aliens have no due process right to be in the United States at all, let alone to obtain a highly regulated conditional privilege or benefit from the government. The Bill of Rights is a futile authority for the alien who has never been admitted to these shores." The policy reason for this decision was obviously the national security interest in the United States. While there may be some wiggle room for a legal argument, allowing compensation for the citizens of Kiribati doesn't pose much of a threat to United States national security, it would probably be a losing argument for standing, as courts would no doubt find that allowing such lawsuits could threaten the nation's economic security. Say, for instance, they requested an injunction halting the production of power until cleaner methods of energy production were adopted. So that leaves international law. Based on my research and analysis, I believe that the only real hope for the citizens of Kiribati in establishing standing is via the Alien Torts Claims Act, which is directed specifically at non-resident aliens. Under the Alien Tort Claims Act, which purports to be a tort claims act, a non-resident alien must establish a violation of the laws of nations. Recently, the statute has been used to bring actions against American corporations, although the law is somewhat unsettled. In the case of Flomo versus Firestone National Rubber Company, argued in the Seventh Circuit Court of Appeals 2011, Liberian citizens brought a suit alleging that Firestone was exploiting children in the labor force in violation of customary international law. The court ruled against Firestone, citing 3 international conventions relating to child labor. So, if the citizens of Kiribati properly allege that the actions of the American utility companies, who would be acting as agents of the United States through their acceptance of subsidies, are contrary to the established norms of civilized nations, they may have standing. This would certainly be an uphill battle, as nearly every industrialized nation is contributing to carbon emissions, demonstrating that if there is a norm, it's to pollute and contribute to climate change. But I think the way for the citizens of Kiribati to state their claim under the ATCA would be to allege that never in the history of mankind has one civilized nation acted in a manner so as to destroy the sovereignty of another nation by submerging it underwater, solely to advance its economic interests. Such a case has not yet been brought. If and when it does, even if standing is conferred, there will still be many other major obstacles on the road to success on the merits. The photographs in this presentation are not my own works. Here is a list of credits to the photographers and organizations responsible for the photography.